In the intricate world of competition law, where cartels wield behind-the-scenes influence over markets and sovereignty itself hangs in the balance at times, South Africa now stands at a pivotal crossroads. In the heart of the storm, the alleged manipulation of the rand, a currency that is not merely a medium of exchange, but a symbol of national economic sovereignty. The Competition Commission, armed with what it says is prima facie evidence, contends that a sophisticated cartel of global and local banking giants engaged in a transnational conspiracy to rig the foreign exchange market. Yet, in the hallowed halls of the Constitutional Court, questions loom. Does the Commission have jurisdiction over foreign entities? Are these collusive machinations sufficiently proven, or does the Competition Appeal Court's skepticism hold firm? So let's unpack it all for you, unpack the complex jurisprudence surrounding this saga, from cross-border enforcement challenges to the evolution of cartel conduct in opaque currency markets with some leading authorities in that area of competition law. I'm joined now by Professor Philip Sutherland from the University of Stellenbosch, who is a competition law expert, as well as Makgale Mohlala, who is manager for the cartel division of the Competition Commission. Good afternoon, and thank you for joining me this afternoon. Let me start with you from the perspective, Makgale, the perspective of the Commission. Just unpack for us, and in simple terms, what did we witness at the Constitutional Court in the last few days? It wasn't the actual arguments with regard to whether or not this conduct has been sufficiently proven, with the result that, consequences should be meted out. We are still dealing with a preliminary issue, are we?
Indeed, it's a preliminary issue. It's interlocutory. So the main issue was really whether the Competition Commission and the tribunal have jurisdiction to prosecute banks that were manipulating the rand outside of the Republic of South Africa. So our argument as the Commission is that Section 3.1 of the Competition Act gives us those powers. Is the section that's designed to ensure that we have extraterritorial powers to prosecute, to investigate and prosecute conduct that have an effect within the South African economy. And, that is the position we have maintained from the beginning, because that is what the law says.
Yeah.
But obviously you will have challenges from the anyone who is facing cartel prosecution. They'll pick up any excuses in order to ensure that they don't get to see their day in court.
Yeah.
So that was basically the main issue at the Constitutional Court this week.
So let me stick with you for a moment, Makgale, before I bring in the Prof. I was saying that you argue as the Commission that you have a prima facie case. This, in simple terms, I imagine means that at the very least, these banks would need to answer to the case. What the finding is at the end of them answering to that case is something that you cannot predict. What is this prima facie case? I know that it was delivered over a number of days of argument, but how can you sum it up for us? What did these banks do?
Correct. We do have evidence which we informed our decision to prosecute the banks. We don't prosecute without evidence. That will be illegal. So we have evidence. We have put it before the tribunal in our referral in 2023. If you have chance, just look at it. We have outlined the kind of things that banks did in manipulating the rand. The tribunal ruled in our favor. They says we have made out the case for the banks to answer and ordered all of them to file their answering affidavit. Unfortunately, they didn't. They challenged the tribunal's decision to a Competition Appeal Court, which ruled in the main against us. That's why you found us at the Constitutional Court, because we are not happy with the Competition Appeal Court judgment. But we have evidence of chat. We've put it out there. It's in the public domain. Traders were chatting in the chat room. Reuters, Bloomberg, they gave them name. The Tsar, the Cartel, the Digit. So they've got names of chat rooms that they were using to communicate among themselves, to agree on what they should do in the forex market at any given time. So the details are a lot. I can go through them, but it's up to you.
Yeah. So, Prof Sutherland, let me bring you in. Having observed the arguments in the last few days, the one overarching, and I use the word overarching, I didn't mean to throw it in there, but let's go there now that I've used it. Single overarching conspiracy, SOC. That seemed to me to be the dominant narrative that was being presented by the Competition Commission in advancing its case. What did you make of the arguments that you heard over the week, as well as the arguments that were presented by the banks?
Right. So the first point, just to connect to what the Commissioner said, is, of course, there's little doubt that there was some collusion here. As mentioned, traders went into chat rooms and they manipulated the rand. Now, the rand exchange rate with other currencies. Now, the first point I think that makes this case difficult is it's not one big fix, and that's the end of it. The exchange rate is now fixed. This is, of course, an incredibly dynamic market, a market where currencies exchange all day, trillions of rands of currency exchange all the time, and they, in other words, they fix it on various occasions for very short periods, because you can't control it in a way that you could say control the bread price. So what you then say is, you say all these different instances of fixing constitute one overall conspiracy. It forms part of a broader aim to manipulate the rand over time. And that is a completely normal way of approaching conspiracies, because you can imagine, and that's the way they do it in Europe, in America, because you can imagine in most cases, if there's a cartel, they don't just meet once and then they have a fix. They have to change it, adopt the circumstances, all that. So that part of the case, I think, is unproblematic in law.
Yeah.
And there are many other cases where the same kind of thing has been decided. But as the Commission points out correctly, the difficulty here lies in other aspects. So the first point they mentioned is the point of jurisdiction. So many of these banks are not in South Africa. The question now is, can our competition authorities reach those banks? Now, this is, of course, an important question in this case, but it is also an important question more generally, because South Africa, we are being buffeted about by international markets. Many cartels concluded elsewhere in the world affect us in South Africa. So I really understand that the Commission is fighting for this point, because it's conceivable that harm can be done elsewhere by people who sit elsewhere. Yeah. Conversely, you can also understand the difficulty of saying, well, how do we get to banks who don't do any business in South Africa? They have no connection to South Africa. So that certainly is the first complex issue here. But there are, of course, other aspects that make this case very difficult. I must say, every time I see it being argued, I'm very happy to be an academic that don't have to deal with these issues as the Commission does in practice. This case has some seriously complex technical issues.
I picked that up.
And I personally have a lot of sympathy for the Competition Appeal Court in that sense.
Yeah, and it was well argued on both sides by some serious legal eagles. Prof, let me stick with you and ask you, why is this question of jurisdiction coming up so sharply in this case? It's always been there, hasn't it, in terms of how the law itself, the statute that empowers these kinds of investigations by the Competition Commission goes, the Competition Act. It's always been framed in that way, that it foresees that some conduct will happen that's not necessarily in South Africa, but its effect is felt in South Africa. What about this case brings up the jurisdiction point so sharply?
So I think in this case, the problem is that there are two issues regarding jurisdiction. The one is there must be actions that have effects in South Africa. And most of the other jurisdictional cases concern that aspect. But in most other cases, the respondents at least had some presence in South Africa. But here, many of the banks who are involved have no connection to South Africa. They do no business here. They traded currency with other banks that are also not in South Africa. So in that sense, they are very far removed from us. And the difficulty is that as a country, we don't really have any control over them. Even if the Commission wins their case, and I think that the Commission understands that, it wouldn't really be possible to fine them. It wouldn't, even if we impose fines, it wouldn't really be possible to enforce those fines. But perhaps it's still important to have a finding that says what you have done is unacceptable.
Makgale, let me get you to address that point. Why is this a case that's still worth pursuing as far as the Commission is concerned? Much of the conduct we're talking about dates back, from 2007 to about 2013 or thereabouts. Why is this the hill on which we are prepared to die as a Commission, to use that expression? Why does it matter to the ordinary South African?
Yeah, so the issue of the jurisdiction of the competition authority is a very important issue, If you have a country that can't control activities that have an effect on its economy, then we are all in trouble. Because if it is ruled that the Commission and Tribunal does not have jurisdiction, it means that, in fact, it's scary to even think about it, because it means that anyone sitting anywhere can do whatever they want to do about anything in the South African economy that contravenes Competition Act, and we will not be able to intervene. So you can think of all international, multinational company or international companies. You've got the online, you've got, all sorts of companies that are not here but are supplying goods here. So if we don't have powers to regulate their behavior that affect South Africans, then it means South Africa is really in trouble, because there's no control. Anyone can do whatever they want to do. It will be like, if you want to do anything, go to South Africa. You will not be caught there because they don't have powers to investigate us. As long as we are not in South Africa. You can go to Lesotho, you can go to Swaziland, you can go to Botswana and do anything that affects the South African economy. So if we don't have jurisdiction, we will not be able to intervene. So that's why it's so important. It's about the Commission being able to do its job in protecting South Africans, in protecting South African economy. And if you take away those powers, it means now, what's the point? So there will be there'll be a party, so to speak. Everyone will come and have a party here, and there's nothing we can do about it.
So, Makgale, just to close the loop very quickly on this point, your intention is, if the Constitutional Court, if they rule in your favor on these points, your intention still is to take this matter back to the tribunal and have it prosecuted to its full extent. Is that it?
Correct.
All right.
We need the banks to have their day in court where we can deal with the merits.
Sure. It's going to be fascinating to see how it all plays out. Thank you for your time this afternoon. That's Makgale Mohlala, who is manager for the Cartel Division at the Competition Commission. We also had Professor Philip Sutherland, a competition law expert from the University of Stellenbosch.